Arizona Attorney General Mark Brnovich was at the Supreme Court today asking the justices to restore laws that ban ballot collecting and reject ballots cast outside a voter's precinct, laws that critics and lower courts say unfairly burden minority voters. Molly Hudson reports on this argument at our Washington bureau today. When does a voting restriction go from necessary for smooth elections to being a substantial burden on the ability to cast a ballot? That was the question the Supreme Court considered today in an Arizona case that has implications for voting rights nationwide. To Arizona Attorney General Mark Brnovich, the two laws don't impose a substantial burden on Arizona voters. He told the justices they are, quote, common sense and commonplace laws.
Requiring in-person voters to cast their ballots at assigned precincts ensures that they can vote in local races and helps officials monitor for fraud. Restricting early ballot collections by third parties, including political operatives, protects against voter coercion and preserves ballot secrecy.
But Arizona Secretary of State Katie Hobbs says the laws are anything but common sense. She said in an interview after today's hearing that if the justices accept Brnovich's argument, it would gut the Voting Rights Act.
The arguments put forth by the Attorney General at the Supreme Court would really literally gut Section 2 of the Voting Rights Act.
Section 2 is the part of the Voting Rights Act that prohibits voting laws that discriminate against minority voters. But courts have differed on where to draw the line, an issue the justices appear to be grappling with today.
This is an important case because Section 2 of the Voting Rights Act, the standards that courts are supposed to apply when evaluating such lawsuits are unclear.
Shapiro said the Supreme Court needs to clarify the standard, but other experts agree that whatever the court decides in the Arizona case will affect voting rights laws across the country.
The larger issue of what kind of standard the court establishes for future Section 2 claims that certain election laws are being put in with a racially discriminatory motive, that's the key thing here.
Shapiro thinks that the two Arizona laws will likely be restored by the High Court, noting that many states have similar laws. Hobbs worries that lawmakers will not wait for the High Court and that laws under consideration now will be harder to fight if the justices uphold the Arizona laws.
And so now the bills that we're seeing in the legislature that would restrict voting even more would be harder to challenge in court by voters in the future.
Another reason the Arizona case is being closely watched, Shapiro says.
Even beyond what happens with these two particular laws, people are looking at this case ahead of the 2022-24 elections to see what kind of litigation might happen.
Arguments in the case went for 2 hours this morning with all parties, including the justices, connecting by phone because of COVID restrictions. The justices are not likely to issue a ruling until later this spring or early summer. In Washington, Molly Hudson, Cronkite News.